Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the Self-insurers in Australia podcast. My name is Alorna Strong and I'm a partner at Hall and Wilcox and oversee our national self-insurance practice, and I'm delighted to be the host of our new podcast series for self-insurers. In this series, you might have heard me say that we'll be discussing topics that are relevant to your day-to-day management of claims as a self-insurer and give you insight into how claims may be managed in various jurisdictions across Australia. So we're about to jump into our final episode in this series and speak to Angela Brooks, who is a partner in our Queensland office, who has many years of experience in the self-insurance space. Welcome, Ange.
Welcome, Alorna.
Thank you. So today I might just jump right into it, Ange, and take you through two scenarios. And basically the purpose of this podcast is to just chat through the two scenarios and determine whether or not these injuries arose out of or in the course of employment. So Emma, a warehouse supervisor in our first scenario, has just finished her shift and was eager to get home. As she was about to leave the warehouse, she realised she had forgotten her personal phone charger at her workstation. Wanting to quickly grab it before heading out, she hurried back to her workstation. On the way back, she slipped on a patch of spilled oil near one of the loading docks and fell, spraining her ankle. Emma was taking a shortcut when she fell over through the loading docks. She did not follow the usual pathway when leaving and arriving for work, as she was in a rush. Now, Ange, taking that scenario into account, what would you say about this injury arising out of or in the course of employment?
Alorna, this scenario is a difficult one, particularly in line with Queensland and its relevant legislation. Most of our case law in Queensland is really directed at pre-duty cases, not post-duty cases. Certainly none of the special turns of our legislations have anything to do with it. What I would say in this particular scenario is if Emma was still tending to any of her work duties, it is possible that the injury will be deemed to have arisen out of or in the course of her employment because she was at her place of employment. Now, the place of employment is a phrase used in the WCRA Workers' Compensation and Rehabilitation Act in Queensland to give rise to a presumption about certain circumstances or journeys involving work or breaks from it, and when there is assumed to be a connection with employment. The general principle is that there has to be some sort of actual relationship between work that is performed by the worker and the location for it to be the place of employment. It is not necessarily to be made with respect to property boundaries. For example, consider the case of large rural properties. However, where work is performed at a warehouse or shop, it might be convenient to consider the whole of the premises to be a place for work. It is unlikely that the designation of the pathway in this particular scenario as a usual one would have a significant impact on whether it was the place of employment within the warehouse, though it may be relevant in the appropriate case. Based on what we know about Emma, it is most likely her place of employment was the warehouse. Now, assuming Emma was not tending to any duties, then the question that needs to be asked in Queensland is, was it a journey claim? In Queensland, it will be presumed that a worker has suffered an injury arising out of or in the course of employment, and work need not be a significant contributing factor if it occurred on certain journeys, including to and from work, providing an exclusion does not apply. We have a decision here in Queensland, Alorna, of Johnston and QComp, a worker who had left home for work, returned home to get her ID required to enter work, and fell down the front stairs of her residence, breaking a bone. It was decided in that case that where a worker sustains an injury at either of the designated points for the journey, the place of employment, or within the property boundaries of the home, then the worker cannot have embarked on a journey between them for the purposes of our Queensland legislation. So in this scenario, applying the facts of the case that you've just mentioned, it seems unlikely that Emma would be entitled to rely on a journey claim. Then we need to look at this idea of recess. In 2019, the Industrial Court determined that an ordinary recess for the purposes of the WCRA included a period of time where a worker is required to attend at a place of work prior to the commencement of a shift. It is possible a similar analogy could be drawn in this particular present circumstances, in which case it would be deemed that Emma's injury arose out of or in the course of employment. The connection remains less obvious, however, than in the arrival cases where there is now work to do compared to where the work has been done, but we still are of the view that it would likely fall that Emma's injury occurred in the course of employment, Alorna.
Okay, you touched on this a bit before, Ange, but that journey part. So if the scenario was altered somewhat and she had actually left work, gotten in her car, went for a driving home or wherever she was driving, and then went, oh, I forgot my charger, did a U-turn, drove back to work, and then as she was returning in that scenario, she slipped over in the oil. Would that make it not compensable? But I think you made some mention about journey claims. Can you just clarify that for me?
Look, the answer is, and particularly from a practical sense, Alorna, in Queensland, I would say that on the basis of the facts, subject to it not being a significant period of time, say, for example, 4 hours in the car, I would still suggest to you that it won't fall within the journey claim notion, but it will fall within the notion of it being an injury sustained in the course of employment.
Okay, interesting. In terms of working out whether or not that claim is compensable, is there any sort of evidence that you might want to gather in defending it? Say it became a common law claim, for example. What sort of things would you look at in terms of defending it? Because there's common law in Queensland, isn't there?
Yeah, that's exactly right. Look, there are a number of evidentiary steps I would undertake. Where precisely was the injury sustained? Was Emma expected to have passed in or around that area in the ordinary course of her duties? Was it necessary to return to her workstation? How long was it between when Emma finished work and elected to return back to her workstation? Had the employer made any, or self-insurer made any inducements or requirements which related to Emma's need to return to the office? Example, was there a tidy desk policy? Were there shared workstations which must be kept tidy, I should say? Now, for the purposes of any damages claim, so when you're looking at negligence, for example, Alorna, what was the substance? Was it obviously detectable on the ground? How did the substance get there? How long had it been there? Did the employer expect there to be foot traffic through the area? Was there any opportunity to clean up the spill before the closure of duties? Were there any warnings which ought to have alerted Emma to its presence? Those types of evidentiary steps should be undertaken in that particular scenario, Alorna. And the scenario is also, it was of interest to me, and I've looked into it a little bit more detail. And I think that it would have made a difference if she was going back to her office, say, to collect her work laptop, or if she had fallen on a designated walkway. It would be a much more clear-cut claim. It would be very clear that certainly there is an argument that there's a connection between the task and her duties, and therefore likely an argument that she was injured at the place of employment in connection with the employer's trade, and that will be much more acceptable to a court. So I would say that in that situation, that slightly different situation, the connection with work would be heightened.
Yeah, okay, excellent. Thanks, Ange. I might head over to the next scenario. So we've got Adam, who was employed as a security guard with Secure Cop on a part-time basis, and depending on the number of shifts he was allocated, he worked 10 to 20 hours per week. On the 28th of May 2023, he was rostered to work as a security guard at the MCG, and I'm not sure what the equivalent is in Queensland, but same. So the
Suncorp
MCG,
Stadium.
yeah, there you go. So the MCG is pretty iconic, so you can refer to Suncorp. So the worker received an email from his employer regarding the gates that were open for him to access to attend work. So Adam was driven to work by a co-worker who parked his car at a car park, we'll say, just outside of Suncorp Stadium, and he entered through gate 7. So whilst walking through the car park to get to Suncorp Stadium to commence work, he slipped and injured his left leg. He then made a claim for compensation for his left leg and knee for a fall that he sustained in the car park that's attached to Suncorp Stadium near gate 7 at 11 a.m. on the 28th of May 2023, and he also alleged a psychological condition. Now, applying your Queensland hat on and not the MCG Victorian hat on, and do you think that this injury arose out of or in the course of employment?
Yes, the cases in Queensland are much clearer with respect to this scenario. It is likely that he has sustained an injury which arises out of or in the course of employment.
And you've suggested that it would be an injury that arose out of or in the course of employment. Are you saying that because it's a journey claim? I'm just trying to clarify with you, why do you say it did arise out of or in the course of employment?
If we have a look at a journey claim from a perspective of a journey claim, we would say in Queensland that unless part of Adam's duties required him to patrol the relevant car park, then it is likely that the car park was not his place of employment. Everywhere connected with the Suncorp Stadium, in our case, is unlikely to form his place of employment. And a natural and sensible approach to travelling to work, parking in the car park nearby, means that it is unlikely that any significant deviation or delay will be established. So I would anticipate that he would be entitled to a journey claim.
Okay, so the fact that the car park wasn't his place of employment or connected to it is probably a red herring because you've got journey claims. So basically when he left work, he would have been covered. Okay, taking that into account, what sort of evidence though would you need, or how would you approach it from a common law negligence perspective, Ange?
From a common law and negligence perspective, I would be considering what would the consequences of non-compliance with the direction to park in the car park be? What was the condition of the car park? What did it look like? How was it maintained? Was it slippery? Was it impacted by ambient weather conditions? And was Adam required to perform any duties in the car park? Those are evidential steps that I would like to undertake before I considered negligence on the part of any insured.
Yeah, okay. So if he wasn't directed to park in the car park, so he could have caught a train, he could have caught whatever other mode of transport, a bus, and got to the stadium, and then he injured himself in that car park, I assume it'll still be covered as a journey claim. So from a workers' compensation perspective, you would be covered. But then from a negligence perspective, if it wasn't a car park that was owned or operated by the Suncorp Stadium, then would that sort of be the angle that you would take in defending that type of claim?
It would likely be the subject of a public liability claim instead.
Yeah.
Here in Queensland.
Okay.
Yeah.
All right. Excellent. Okay. Thanks, Ange. I really want to thank you. That was really informative. And I'd like to thank everyone for listening today. That was the final episode in this podcast series. So I'm hoping you're enjoying our podcast so far. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's podcast episode, then rate, review, or follow our podcast whenever you get podcasts. Thank you, and bye for now.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.